within 10 days after the Attorney General files a sex offender civil management petition, the respondent may file in the same court a notice of removal to the county of the underlying criminal sex offense charges. The Attorney General may, in the court in which a petition is pending, move for a retention of venue. Such motion shall be made within 5 days after the AG is served, but the time may be extended. That one little index card spurred a 5-minute reading of the Real Property Action Proceeding Law from 760. What is this? Where did I even start? I went all the way back to 756 and went to the end of the article. So all of that little index card. 761, Redemption by Lessee. Where the special proceeding is founded upon an allegation that a lessee holds over after a default in payment of rent and the unexpired term of the lease under which the premises are held exceeds 5 years at the time when the warrant is issued, the lessee or his executor, administrator, or assignee at any time within 1 year after the execution of the warrant, so actual eviction, because that's what they mean, the warrant of eviction. So after execution of the warrant, unless by the terms of the lease, the lessee waives his right. So they basically put that in all the agreements now that you're waiving this right. Shall have waived his right to redeem, or such lessee, executor, administrator, or assignee shall have subsequently waived the right to redeem by a written instrument, filed in the office where the lease is recorded, or if so not recorded, in the office where deeds are required to be recorded of the county in which the lease premises are located, may pay or tender to the petitioner, his heir, executor, administrator, or assignee, or if within 5 days before the expiration of the year he cannot be found with reasonable diligence within the city or town where the property is situated, then to the court which issued the warrant, all rent in arrears at the time of the payment or tender with interest thereon, and the costs and charges incurred by the petitioner. So, this is saying that at the time that the warrant of eviction is executed, there was a remaining 5 years or more on the lease. Within 1 year after the execution of the warrant, they can pay all costs, all rent arrears, and all expenses either to the landlord or to the clerk of the court if they can't find the landlord with reasonable diligence. And thereupon, the person making the payment shall be entitled to the possession of the demised premises under the lease and may hold and enjoy the same according to the terms of the original demise, except as provided in 765. Okay, so then in 763, it's redemption. 763 talks about redemption by creditor of lessee. So unless the judgment creditor waives this right, or the lessee or his executor or administrator waive the right, or something, then the creditor of the lessee can file a notice in the court which issued the warrant of eviction, specifying his interest and the sum due to him, describing the premises, and stating that it is his intention to redeem as prescribed in this section. If a redemption is not made by the lessee or his executor or assignee within a year after the execution of the warrant, the person so filing the notice, or if 2 or more persons have filed the notice, the one who holds the first lien at any time before 2 o'clock of the day, not a Sunday or a public holiday, next succeeding the last day of the year, may redeem for his own benefit in like manner as the lessee, his executor, administrator, or assignee might so have redeemed. Where 2 or more creditors or mortgagees have filed such notices, the holder of the second lien may so redeem at any time before 2 o'clock of the day, next succeeding that in which the holder of the first lien might have redeemed, and the holder of the third and each subsequent lien may redeem in like manner before 2 o'clock of the day, not a Sunday or holiday, next succeeding that in which his predecessor might have redeemed. But a second or subsequent redemption is not valid unless the person redeeming pays or tenders to each of his predecessors who has redeemed the sum paid to him to redeem, and also the sum due upon his judgment or mortgage, or deposits those sums with the court for the benefit of his predecessor or predecessors. So basically, if the first judgment creditor paid all that stuff, to redeem, but then didn't redeem, then these other people would have to, I guess, pay that guy back. Okay, 765, effect of redemption upon lease. Where redemption is made, the rights of the person redeeming are subject to a lease, if any, executed by the petitioner since the warrant was issued, so far that the new lessee, his assigns, undertenants, or other representatives, upon complying with the terms of lease, may hold the premises so leased until 12 o'clock noon of the first day of May, so May 1st, next succeeding the redemption, and in all other respects, the person so redeeming, his assigns and representatives succeed to all the rights and liabilities of the petitioner under such a lease. So if there was a new person in the commercial space, this is talking about commercial space, they get to hold the place until 12 o'clock noon of the May 1st, next succeeding the redemption. 767. Order of redemption, liabilities of persons redeeming. The person so redeeming as prescribed in this article, or the owner of the property so redeemed, may present to the court which issued the warrant of eviction a petition setting forth the facts of the redemption and praying for an order establishing the rights and liabilities of the parties upon the redemption, whereupon the court must make an order requiring the other party to the redemption to show cause at a time and place therein specified why the prayer of the petition should not be granted. The order to show cause must be made returnable not less than 2 nor more than 10 days after it is granted. I think they mean after it's signed. And it must be served at least 2 days before it's returnable. Upon the return thereof, the court must hear the allegations and proofs of the parties and must make a judgment as justice requires. The costs and expenses must be paid by petitioner. The judgment, or a certified copy thereof, may be recorded in like manner as a deed. A person other than lessee who redeems as prescribed in this article succeeds to all the duties and liabilities of the lessee accruing after the redemption as if he was named as lessee in the lease. Jurisdiction, venue, and court. A special proceeding by tenants of a dwelling in the city of New York or counties of Nassau, Rockland, Westchester, Suffolk, all those counties, for a judgment directing deposit of rents into court for their use for the purpose of remedying conditions dangerous to life, health, or safety may be maintained in the civil court of the city of New York, the district courts of Nassau and Suffolk, and the county court or city court in Rockland or Westchester. The place of trial within the county of the special proceeding shall be within the county in which the real property or a portion thereof from which the rent issue is situated. Okay, so now with all that said, I can answer this index card. In order to show cause for an order of redemption must be made returnable not less than 2 nor more than 10 days after it is granted. So again, in order to show cause for an order of redemption must be made returnable not less than 2 days nor more than 10 days after it is granted, and it must be served at least 2 days before it is returnable. Upon the return thereof, the court must hear the proofs and make a judgment. 755, I believe. So this is about failure to make repairs. During the continuance of the stay, the court may direct in its discretion upon 3 days' notice to all parties the release to a contractor or material man of all such part of the monies on deposit, because the tenants have to make their rent payments to the court instead of the landlord while this repair thing is going on. And again, this is in 755, I believe. Upon a showing by the tenant that the landlord is not meeting his legal obligations, therefore, direct such a lease to municipal departments to pay the bills and expenses for the maintenance and repairs upon the showing. Upon the entry of an order vacating the stay, the remaining money deposited shall be paid to the plaintiff or landlord or his duly authorized agent. Neither party shall be entitled to any cost in the proceeding or action wherein the stay shall be granted, except that costs may be awarded against the tenant in the discretion of the court in the in the event the condition complained of shall be found to be due to the tenant or the defendant. So if he caused the problem, then they can get $25 in costs against him. 756. Stay of summary proceedings or actions for rent under certain conditions. In the event that utilities are discontinued because of the failure of the landlord or other person having control of said multiple dwelling to pay for the utilities for which he might have contracted, any proceeding to dispossess a tenant from said building or an action against a tenant for rent shall be stayed until such time as the landlord or other person pays the amount owing for said utilities and until such time as they are restored to working order. 761.